DCF appears by and through Ms. Ridgway. Mr. Kingsley appears in person and pro se. We were most recently here on June 16 of this year, at which time the parties appear as they do again today, and the matter was continued from that date to today's date. I note that the immediately preceding hearing was one where there was indication that an income withholding order was paying bi-weekly, and that there has been at least some progress in the case at the time of the last hearing so as to warrant continuance to today's date. Ms. Ridgway, can you update the court from the perspective of DCF?
Yes, Your Honor. I think the best way to put it is, wow, we have a problem.
Okay.
Mr. Kingsley was paying by income withholding order. However, on July 27th, DCF received an income tax refund from the IRS in the amount of $35,929. That paid his case in full and resulted in the termination of the income withholding order. However, when I saw that payment, I became extremely suspicious because Mr. Kingsley has no history of employment that would lead me to believe that a $35,000 income tax refund was warranted. I did some urgent, and Your Honor, I discovered this on Wednesday as I was preparing for court. I did some urgent checking to make sure, that my computer didn't have a problem. And I have verified with the IRS that they did actually send us that money. But as soon as they find out that they probably made a big mistake, they are going to demand that money back. Unfortunately, my system, once we receive a payment, we have to distribute it within 24 hours. So that money has already gone to the mother. I have tried to reach out to the mother to discuss my concerns, and I've not been able to make contact with her. I spoke with her for about 10 seconds and the call was disconnected. I'm unable, I've called her dozens of times since then, and I get her voicemail is full and not accepting messages. I have emailed her. I've had other state employees try to call her thinking maybe she's avoiding my phone number. So maybe using a different phone number might result in contact, and that has been unsuccessful. Now, I spoke briefly with Mr. Kingsley about this matter on Wednesday. I did not have a lot of time to speak with him, and I told him we could discuss this further at today's hearing.
Okay.
But what I can say right now, Your Honor, is that I have no debt to collect because it appears to have been paid in full. But unless Mr. Kingsley can explain why he was entitled to almost $36,000 from the IRS, my debt is actually not paid in full.
All right. Mr. Kingsley, is there anything, sir, that you would like to offer?
Like I said, I did something on Facebook, I talked to some lady on the phone. They said it was a real check. So they put this in out to the mail, I didn't get the check. That's all I know. I did stuff on Facebook, and that's all I did.
Okay.
Now, I had to take the picture of my ID. I had to take a picture of me and everything to get that check. So they said that check is a real check. That's what they told me on it. Yeah, they told me on did the video chat that it was a real check.
Right.
That's what they told me on the, yes.
Mr. Kingsley, who is they?
IRS people. Some lady, I don't know who it was on the video chat. They did a video chat with me. They said, and I asked them, I said, is the check real? They said, yes, it's a real check.
And do you know how you contacted them?
It's on Facebook.
And did you provide them with pay stubs or any?
No, all they did, they told me to take a picture of my ID, my social security card, and take a picture of me, and that's what they did. That's all they did. Then I had to do an ID, stuff about ID stuff, and take a picture, and they went through, and they called me on ID, did a video chat with me, and they said it was a real check. That's all I know.
Well, it appears to be real money from the IRS. The problem is, what right did you have to get that money?
I don't know. They didn't say nothing. It says like I guess like a loan or something, or credit or something. That's all they said.
Did you tell them that you were an employer?
They didn't ask me. They didn't ask.
But they told you it was a loan.
It was like something like that. Yeah. I've been texting. I got the number, but I've been texting them on it, and they haven't been texting me back.
I don't know if this could possibly have anything to do with these circumstances, but I know Mr. Kingsley has been, over the long arc of this case, at least sporadically employed with W-2 employers. And I don't know all the intricacies, but I wonder if there was any conclusion that he was entitled to earned income credits for some period of years, which could manifest itself in a number similar to the one you're explaining. I mean, I have no idea if that's the logic, and I don't know, Mr. Kingsley, I'm not implying that the people you were interacting with were anything other than what you believe them to be, representatives of the IRS, but from the perspective of the court, the idea of, holding up identification paperwork and social security cards on a Facebook video, it just doesn't sound what I would have expected anyway, in terms of taxpayer interaction with the IRS. So I would just encourage you to use due caution in interacting and releasing any of your important personal data. I don't know, Ms. Ridgway, if this makes sense to you, and I'm happy to hear from each of you as to a potential way forward. But what I would like to do would be to continue this case for 60 days in hopes that if there is some fly in the ointment, so to speak, in terms of the issuance of that check, that might come to light in the meantime. And if for whatever reason it is indeed exactly issued as it was supposed to have been, then I think that changes the character of what we do going forward if the case is indeed paid in full at that point. Does that make sense from DCF's perspective, or did you have some other suggestions or concerns?
No, Your Honor, that does make sense. My big concern, well, first of all, this money did come from the IRS.
Mm-hmm.
So I have verified that. I don't know, we received Mr. Kingsley's income tax refund in 2020, when we also received his COVID stimulus money, but I believe that is the only time we have ever received an income tax refund for him. The payment history I show for the last 11 years, while he may have had some actual employment, it hasn't been significant enough really for Mr. Kingsley. When was the last time you filed your tax return?
Oh, I haven't done it lately.
And I know you did in 2020 because
that's the last that year I did it. And I haven't had a job at that time.
Yeah. Did you do it yearly before then?
Nope.
Okay. And do you have children in your home? Have you for the last 12 years?
Nope.
So, Your Honor, I'm not a tax attorney, but I believe earned income credit requires children in the home.
Right.
If this is a loan, if Mr. Kingsley, led the IRS to believe that he was a small businessman, I know those loans are available.
I think that's what my lady did for me. I don't know what she done. She helped me to do it.
Well, in which case, if that's the situation, then now Mr. Kingsley owes the IRS money rather than owing child support money. My concern is that the IRS is going to change its mind. And since DCF has already distributed the money, the state of Kansas has to repay the IRS out of the taxpayers' coffers. So I have some people with contacts directly with the feds. I think a 60-day continuance would give us the opportunity to verify whether or not this is legitimate. And if it is, then yay, Mr. Kingsley's done with us.
Okay.
If it isn't, then we have a whole nother set of issues. And please understand, Mr. Kingsley, I'm not saying you tried to do something intentionally wrong. I think you intended to do the right thing with all of this. It's just that I worry that there may have been some big misunderstanding.
Okay.
All right. Well, with all of that in mind, I'm going to look ahead here to October 20, 2023, at actually, Ms. Ridgway, this would move it a little further out, but would you have any objection if the court were to use November 3 instead of October 20?
No, that would be fine.
All right. We'll do that then. November 3, 2023 at 9 o'clock. And Mr. Kingsley, we'll look forward to seeing you back here then. Thank you, sir.
All right.
Mr. Kingsley, if you could maybe call the IRS and ask them for copies of documents.
I've been texting them. Don't get me wrong. I got the number. I've been texting them and things, see what's going on. And I texted them the other day, find out if the check was real, and they haven't texted me back yet.
Okay, well, it was real. It just came to me instead of you.
That's because I've been texting them, hon. Like I said, I texted them the other day. Yeah, I said, is the check's real? They haven't texted me back yet.
Okay, well, if you could maybe even just call the IRS, I'm sure there's a toll-free number somewhere to call and ask them to mail you copies of the paperwork. And then if you could provide that to me, that'd be fabulous.
I see what I can do. I have to go to work, so.
Okay.
Yeah.
All right. Thank you.
Thank you, Mr. Kingsley.
Your Honor, he appears to be driving. I am not comfortable having a hearing with somebody who is appearing by video while driving.
Mr. Coim, I can't hear you. You appear muted, but if you can hear me, are you able to briefly pull off the road in a safe place so that we could take up this matter?
You're still muted.
Okay, there's on mute.
There we go.
Okay. Are you, Mr. Coim, stationary or are you moving in your vehicle?
I'm stationary.
Okay, and you're parked in a safe place?
Yes, it's in a safe.
Okay.
Yeah, I would ask that we have video, Your Honor, of both parties.
Okay. And Mr. Coim, can you connect your video, sir?
It's going in and out.
Okay. Okay. All right. We are on the record in the matter of the marriage of Aaron Coim, now Murray, and Robert Robert. The DCF appears by and through Miss Ridgway. Miss Murray appears in person and pro se. Mr. Coim appears in person and pro se. We're here on a DCF motion seeking to modify support. Support had previously been fixed in the amount of $243 per month. The DCF has filed a motion seeking to modify support, which includes various supporting documents and is such that the final request, at least in the most recent child support worksheet available to the court, is that support be modified to $335 per month. Ms. Ridgway, was there any additional information or prayer that DCF has at this time?
Yes, Your Honor. Since our last hearing, I've received verification of income from Ms. Murray. She emailed me yesterday. I'm sorry, not yesterday, last week, with a copy of her W-2 from a Methodist church showing her annual income from there, a copy of her pay stub from the Wichita School District showing her income from there. And Ms. Murray, just quickly, I noticed on that pay stub that you have a monthly income of $5,854.95 a month. Is that 12 months out of the year?
Well, as a teacher, I get paid, 9 months for working 9 months. I have the option to take it in that 9 months and get a lump sum in May, or I can get it paid over 12 months. And I usually do the 12 months. So I have a paycheck every month.
Okay, but is it $5,854 times 9 prorated over 12 months? Or is it $5,854 every month of the 12 months?
that would be, I honestly don't know that answer. I'm sorry. Because, and part of that's because as a teacher, my salary changes when I sign my new contract. So that monthly amount will go up too.
Okay, what's your annual salary?
My annual salary right now is 73,000 per contract.
Okay.
And I could send that contract.
73,000?
Yes, ma'am.
Okay. And each school district is a little bit different. I think it's common for teachers to get paid 12 months, but only 9 months worth of income.
Right.
So I needed to verify that. Your Honor, I also received from her verification of the health insurance, medical, dental, and vision that she provides for the children. And to be honest with all parties, I simply have not had a chance to redo the child support worksheet. There were some issues with the worksheet filed with the motion that I needed to correct. Primarily, we had assumed in that motion that the parties were actually sharing all expenses for the children, when in fact, Ms. Murray is responsible for paying all of the direct expenses for the children. That makes a significant difference in the child support obligation. That changes it from an initial request for an increase to a net result of a significant decrease in child support. And Your Honor, I also have a concern. Ms. Murray had expressed that perhaps the parties aren't actually exercising true shared custody, residential custody of both of the children at this time. I'm not sure if this is a week on, week off. If that's how it's done, but I believe one of the children has been full-time with Ms. Murray since December. So with all those things that I'm just now discovering, and I simply have not had a chance to redo the child support worksheet, and I would request a continuance to have that opportunity to do so. And I'll reach out to the parties by email. I've emailed both of them directly, so I know we can communicate that way. Reach out to them by email to verify some additional information as it comes up.
All right. Ms. Murray, does that proposed way forward make sense from your perspective?
Yes, sir.
Mr. Coyne, does that make sense also from your perspective, and taking into account that you do and will have access to tell your side of the story, so to speak, to Ms. Ridgway as this matter plays out?
No, sir, it does not.
Okay, what would you prefer the court do?
I would like this motion to be dismissed.
Ms. Ridgway, it puts you at a pretty big disadvantage, but I suppose if you're talking about the information that you have at this juncture potentially being a significant decrease from the whatever, I think it was $253, $243 per month. I don't know whether that augurs for any.
Your Honor, I have no objection to dismissing the motion. I think at this time, though, it's actually up to Ms. Murray. As we have started the process, she's involved in the process, and I think she has the right to demand that we pursue this if that's what she wants to do, or I happily dismiss the motion.
And Ms. Murray,
I have multiple reasons as to why this should be dismissed. One, I have talked to the DCF officer one time for about maybe 30 minutes, sent multiple emails. Don't know if they got there or not. I told her that I cannot maintain employment. I have mentioned multiple things. She is saying that Andrew, one of the children, is staying with Aaron full time. And that is an agreement that is in our court order, saying that we will work with one another for the children to stay at friends and family on each other's parenting time. Andrew has been going to therapy. Andrew has been requested to be at my place multiple times during my parenting time, and still he chooses to be at his mom's. And I'm allowing this to continue because I don't want to force him or make him cry or anything else that would hinder or hurt our relationship. Now, if the court is saying that that isn't not how it's going to be on the child support worksheet, then we're going to have issues between me and my son. And I do not wish, and I pray the court does not see it that way.
Well, actually, where I was in the process, Mr. Coim, was to ask Miss Murray what her position was with regard to your request that the motion be dismissed. So I'm not entirely sure I understand what you thought the court was deciding, or how you perceived those events differently, such as to prompt you to say what you were just saying. But I was, in all candor, simply trying to ascertain from Miss Murray what her position was on your request.
Okay, I apologize. Thank you.
Miss Murray, what is your position with respect to Mr. Coim's request that this motion just be dismissed at this point?
I'm kind of torn, I guess I would say. I mean, it'd probably be easier at this point if it was dismissed. But
Well,
then
I don't want you to feel any pressure. I'm just trying to understand your heart. I know, and I get the sense even from hearing from Miss Ridgway and her exploration into the case, and from Mr. Coim and from yourself, I recognize there are a lot of moving parts. And I also realize that we haven't drilled down completely to, dollars and cents kind of an answer on this. But I did not know, and I didn't want to presume to know, given that Mr. Coim had asked the court to at least consider dismissal of the motion, what your position would be. And again, I don't want you to feel any push or pull on that. I'm just trying to ascertain whether you would want to do that, or you would prefer to go forward with the continuance as Ms. Ridgway had originally suggested.
I think I would prefer to go forward with the continuance. And while Andrew does stay with me, that doesn't have to play an effect on there. I mean, I know it's but by court, he is still 50-50. So.
Okay. All right. Well, and it sounds like, and again, I don't presume to know all of the inner workings, but it seems like from what I'm hearing, both you and Mr. Coim are striving to do what you think is best for the kids, and I applaud each of you for that. I do think it makes sense to continue this. Ms. Ridgway, how much time do you think you'd reasonably need to make certain that you heard everything that was on Mr. Coim's heart, everything that was on Ms. Murray's heart, and to run it through the methodologies for the worksheet in order to get an updated worksheet available for the court?
Your Honor, I think September 15th would give me enough time.
Okay. If I were to set this for September the 15th at 10 o'clock, would that work on your calendar, Ms. Murray?
Yes, sir, I believe it should.
All right. And Mr. Coim?
Okay, I believe 15th is okay. What time?
At 10 o'clock?
Okay, that's fine. And another question.
But before I'm happy to hear your question. I just wanted to say to both you and Ms. Murray that if it's more comfortable or easier for you, you're welcome to use the same meeting ID and passcode that you used today to come into that hearing.
Okay.
Thank you.
What was your question?
Miss Harrison, I believe is her name.
Ms. Ridgway?
Yes, Miss Ridgway. I'm sorry. Miss Ridgway, I have requested documentation from you for all the documentation that you have received. I haven't received anything before the meeting today.
Yes.
Am I going to get a copy of what documentation you have gathered before the next court hearing?
Yes, I will email you both copies of all the information I had gathered. I hadn't forwarded you anything yet because I knew Ms. Murray had sent me an email, and I've just been running behind. I hadn't had a chance to go through the information she's provided, and I wanted to have it all gathered up, and I will send you both all the information that you have each provided for this modification review.
Okay, because I know I had asked for it prior and I hadn't received it. I just wanted to make sure I didn't miss it.
Prior to now, all the information we had is what you had provided. So now I have Ms. Murray's information as well.
Okay, because on our call, you had said that you had it. Okay. Thank you.
You're
Mhm.
welcome. We'll look forward to seeing you both September 15th at 10 o'clock. Thank you. DCF
Thank you, Your Honor.
through Mr. Getz. Ms. Bergen appears in person and pro se. Mr. Weaver appears in person and by and through his counsel, Joshua Andrews. I'm showing that we were last here on the 21st of July, at which time the parties appeared as they do again today, save that Ms. Ridgway was in for Mr. Getz at that time. The matter was continued to today's date. I have reviewed the answer, and as far as I'm taken to understand, the primary objection that Mr. Weaver had was with regard to the calculation of the support and the child support worksheet, which the proposed worksheet I'm looking at shows that proposed support to be $518 a month. Mr. Getz, has there been any additional information, or do you have any update or prayer for the court?
Judge, the wage that we used for Mr. Weaver on that worksheet came from his employer. It is different than the wage which is written on his domestic relations affidavit, which is filed on June 30th. Yesterday, I sent an email to Mr. Andrews asking if he had a copy of a pay stub that would support the number that's written on the domestic relations affidavit. And I've been in court all morning, so it's possible that I've missed an email or a phone call. But at the moment, I don't know what wage to use for him, and I'm looking for documentation.
And what I could advise the court is I did see the email from Mr. Getz. Unfortunately, I didn't have time to do anything with that before today's hearing. But what I can advise the court is the difference in our respective proposed numbers is so minuscule that my client is willing to just agree to the worksheet proposed by DCF if that resolves the matter today.
All right, Ms. Bergen, the counsel for Mr. Weaver has suggested that any difference that there may be between the numbers that he and DCF had used in the calculation of the worksheet monthly payment is small, and as a consequence, they're prepared to go forward with the court setting support in the amount of $518 per month. Do you have any feelings about that one way or the other?
One question, DCF, they were supposed to call me, and they never did. So I still have a question as far as the assistance. They said they were going to lower it. And so I would like to know what that final number is before I agree to anything. Right now, I really have no idea what.
Ma'am, are you referring to food assistance or daycare assistance?
Yes.
Okay.
Yes, daycare.
So that is a separate entity from me. I'm a contractor. All I do is collections. You're going to have to talk to your caseworker that handles your food stamps or your child care. I can't answer that question for you. I'm sorry.
Okay. Okay. And they're not giving me a call back. Because who was here on our last hearing? It wasn't you, Philip. It was somebody in.
Her name was Brandy Ridgway. She's my boss.
Yeah. Okay. Okay. Okay.
Okay, well, based upon the information available at this snapshot in time and in the context of the matter having been continued at least the one previous time, I think it does make sense to move forward, and I will set support in the amount of $518 per month. Mr. Getz, can you advise as to what start date you're anticipating or requesting?
Judge, we're asking for September 1 as the start date, and then a judgment for $2,072. That's the $518 a month for the 4 months the case has been pending, May 1 through the end of August. With regard to repayment of that $2,072, and in recognition of the fact that we do have an agreement on current support, I'm open to discussion on how that gets repaid in addition to the $518.
All right. Mr. Andrews, do you agree first with the proposed judgment calculation? And if so, do you have in your client's big picture interests a proposal as to how that should be repaid?
Your Honor, we would ask that the judgment be offset against some payments that my client started making directly to Ms. Bergen, and I can provide proof of the amounts of that. Otherwise, no objection to what would essentially be a commencement date of May 1, with the understanding that that then creates the arrearage minus what has already been paid directly. And I believe my client would be willing to pay an additional amount each month to catch that up.
Is there amount, and if we need to go mute for a second, if you'd like to speak with him. Is there an amount that would be workable in his bigger picture budget as far as any contribution towards any arrearage in the case?
Let me check, Your Honor.
Okay.
Would an additional $200 on top of the 518 be sufficient to towards the arrearage?
That more than satisfies the agency, but before we do that, is there an agreement on how much was paid directly? Do we know that number?
I don't know off the top of my head. My client just told me this when he came in today that he had made some payments.
Okay.
He did.
Ma'am, do you have a ballpark on that?
Correct me if I'm wrong, but Jacob, I believe it's been 3 checks, 3 weeks worth, so around 387. I believe it was.
I came up with $391.50 based on what my client thought it was. And again, he's going to get me the canceled check so that we can verify, but it should be in that ballpark of 384 to 391.50.
Okay. It seems like if everyone is agreeing to the general principle of payments having been made, and if the amount is very close from everyone's recollection, do we want to leave this open in such a way so as to attain to precision by submission of additional documents, or should we consider some other way forward, given that, what are we talking about, $7 difference?
And Your Honor, what I was going to propose is that my client can get those canceled checks to me very quickly, and I was going to email them to Mr. Getz, so that I think that we could then just, the journal entry would reflect the amount of the judgment. I don't think we would need a further hearing on that.
Okay. Well, I just want to make sure Ms. Bergen is also.
I can include her on the email, Your Honor. Just so that,
I just feel like if we're talking about a cap of 391 or 391 and change, I think if it were different from that, and if the parties, including Ms. Bergen, were not in agreement, we could have another hearing. But I think that it seems like there's a way through the wilderness that might make it easier for everyone. And Mr. Andrews, I appreciate your efforts to assist in making those documents available to Mr. Getz. So again, the order $518 per month, current child support effective September 1, 2023. A judgment of $2,072 for the period May 1 through August 31, 2023, to be reduced by up to $391 as is submitted by Mr. Andrews, and with a $200 per month in addition to the 518 payment to be included in any income withholding order until the arrearage balance is paid in full. Does that accurately summarize what the discussions have been from your perspective, Mr. Getz?
Yes, Judge. Thank you.
All right. And Mr. Andrews?
yes, Your Honor.
All right. Ms. Bergen, is that in line with what you understood, ma'am?
Yes.
All right. Well, those will be the orders of the court, and through Mr. Getz, Mr. Garrett appears in person and pro se. Ms. Wright also appears in person and pro se. We are here originally on the motion to decide support that was filed May 17 of 2023. Service was obtained on Mr. Garrett by tacking and mailing on 5/25 of 2023. Court generated, a child support worksheet generated by DCF proposes that the court should fix support in the amount of $875 per month. After there was no answer or other responsive pleading, there was a motion for default judgment for support that was filed on July 7 of 2023, and we appear here ultimately on that motion. Mr. Getz, has there been any change or update that DCF would like the court to note at this time?
Judge, between the time that we filed the petition with the proposed worksheet and today, the tax ramifications have changed just a little. The number now on the worksheet, $845 per month. That's with minimum wage imputed on mother's side and an income of $4,073 per month on father's. That came from a letter from his employer, Sherwin-Williams, indicating that he earns $940 a week.
All right. Thank you, counsel. Mr. Garrett, is there anything you'd like to say, sir, about the proposed child support order of $845 per month?
No, sir. If that is calculating that I have them for 35% of the time, then that's good with me.
And Mr. Getz, is that calculation in any ways part of your computation here?
No, Judge, I have no adjustment for extended parenting time. In order for me to feel comfortable doing that, I need a court approved parenting plan, and there is no such parenting plan right now on file in this case.
Yeah, I
He
don't
would
see.
be, if he in fact has the child 35% of the time, though, Judge, he would be entitled to a credit.
Right. Miss Chelsea, I'm sorry, Miss Wright, what is your position with respect to the proposed child support order in this case? And what response, if any, do you have with regard to Mr. Garrett's concerns about the significant time he would be caring for the kids in an extended way?
Is it stating that he has them 35% of the time, or that he would like to have them 35% of the time?
He is stating that he has them 35% of the time and is asking the court to consider that in any child support order that I might make.
Unfortunately, I do not believe that he has them 35% of the time, because he only has them for 2 full days. I do not believe that is 35% of the time. And honestly, I would prefer to ask for a tad bit more, because of the fact that I do have them full time, and I financially and I solely take care of them and their well-being. Everything that they need, I do. He does not do anything for the kids. He has them 2 days. He does not take them anywhere. He does not take them to doctor's appointments. He does not ask to take them to doctor's appointments. He does not even ask for about their doctor's appointments or anything that they have to do. I can't even half the time get him to take his son to school for 1 day a week. So I am sorry, but I wish that the court would reconsider and ask for more.
Mr. Getz, having heard obviously disparate positions from Mr. Garrett and Ms. Wright, and also taking into account the information available at this time, does DCF have any particular proposed way forward at this point?
Well, Judge, I'm going to stand on my worksheet of $845 per month. If Mr. Garrett wants a continuance so that he can pursue a parenting plan, that's within the court's authority to grant. Likewise, the guidelines do allow the court to enter an overall financial adjustment for the non-exercise of parenting time, but both of those are very fact-driven situations, whether it's a non-exercise or extended exercise. And frankly, I think it's beyond the purview of just a simple docket call today.
Mm-hmm. Well, I do think that, each of you have been pretty passionate in expressing what you thought the court should do, and those pull in obviously very different directions. I am willing to continue this so as to allow an opportunity for a parenting plan to be worked out, and for the parties to update Mr. Getz at DCF if any such parenting plan should be agreed upon and included in the case. But I think that if there isn't more in the way of facts that the court can rely on, and I know from each of your perspectives, you're telling me what you believe to be the truth, and in your minds, those are indeed meaningful facts, but there would need to be some corroboration of any of those sorts of facts. And if there weren't those kinds of things in place, I would be moved to consider very carefully doing as Mr. Getz has asked me to do, and just order support in the amount of the $845 a month, which takes into account all that is known and confirmable at this point concerning the finances that are to be considered in this case. So I'll continue this. You are able to come in by way of the same Zoom meeting ID and passcode that you used today. I'm inclined to continue this, Mr. Getz, to the 6th of October. Does that date and time work on your calendar?
It does, Judge.
All right. I will continue this then to October 6, 2023 at 2 o'clock in the afternoon. Sorry, let's do it at 3 o'clock that afternoon. And Ms. Wright, does October 6th at 3 o'clock work on your calendar, ma'am?
Yes.
All right. And Mr. Garrett, October 6th at 3, does that work on your calendar as well, sir?
It should. I have to take off work. I work from 2 to 10:30 p.m. and I have to take off vacation 2 hours at a time. So
okay.
I should be able to.
Okay. Well, I'm hoping having it at 3 and what were your hours again, did you say?
2 p.m. till 10:30 p.m. I get breaks every 2 hours, so I have to schedule my vacation every 2 hours.
Mhm. Mr. Getz, I know that there might be some challenge and depending on how many facts each of the parties may be asking the court to consider, it might be a challenge to try to work it in a half an hour. And I recognize that this might be requiring Mr. Garrett to zoom in from the parking lot at work, but would 1:30 that day work on DCF's docket?
It does.
Okay. Do you think, sir, that that would be helpful to you at all? I mean, like I said, I couldn't guarantee we'd get everything finished in a half an hour, but it might give you an opportunity at least not to have to take vacation time. But I'm happy to leave it on at 3 o'clock if you'd prefer that instead.
I can do 1:30. Yes.
All right. We'll set it then at 1:30 on October 6th. And Ms. Wright, does that work for you, ma'am?
Yes.
Okay. Well, we'll see everybody here then at 1:30. And like I said, if there's any further document that you wish to file in the case, you may. If there's any further discussion that seems important for you to undertake with Mr. Getz, of course, you may do that. But it's important that we try to be in a posture where I can hear fully and consider all of the positions that each party has. And we'll try to get that done at 1:30 on October 6th. Ms. Warner, sorry, Ms. Burnson appears in person and pro se. Mr. Warner does not appear. We are here after having been here last, let's see, June 2nd of this year. At that time, it was noted that there was approximately $5,650 in arrears. It looks like support was set at $620 per month, and that there was an application of bond money to a balance. The case was continued to July 21 with the expectation that if the case was paid in full, the contempt would be dismissed. Mr. Getz, have you had any additional information or any update on this case you could report to the court?
Judge, there was a $5,000 lump sum payment made on August 9th. He does still have an arrears balance, though. Through the end of July, that would be 1,908. Then the 628, which is due for August, giving him a total owed through the end of this month, 2,536. My notes from June 2nd are that he was ordered to pay $650 every month, and he did not make payment in June or July. And then we have this lump sum payment in August. Again, that was on the 9th. I do not see, as part of the notes from the June hearing, any indication that he would be excused for a lump sum payment, nor do I see any notes that he has contacted us with a request to be excused. So I do not know why it is that he is not present and participating today. While I do appreciate the fact that he made a $5,000 payment, he is still in violation of the court's order, which is to pay each and every month. And based on his failure to appear again today, I would once again ask for a bench warrant and suggest $500 as the cash bond amount.
All right. Ms. Burnson, is there anything you'd like to say, ma'am?
Nope, I don't have anything to say.
All right. I'm a little bit torn to the extent that the payment was indeed meaningful and moved Mr. Warner largely in the direction of what my notes indicated would be a potential dismissal if the case were paid in full. But as Mr. Getz has indicated, it's short of being paid in full, not only because there's still a $1,906 arrears balance, but because as of August 1, there was an additional $628 due and owing. And I do not likewise see anything in my notes that would have indicated that there would be any unilateral ability on Mr. Warner's part to come or not come to this hearing. So I will indeed authorize a warrant issue And I will fix bond in the amount of $500. Mr. Fleury appears not in person, but by and through his counsel, Joshua Andrews. Ms. Ross also does not appear in person, but does appear by and through her counsel, Lacey Gilmore. This matter was previously on the docket several times in recent months. Importantly, it was on the docket on April 21, at which time there were discussions of additional child support worksheets being submitted. And in fact, I think council have both submitted multiple child support worksheets in the interim. I had originally indicated that I would be making a ruling based on those submitted exhibits on June the 2nd. I failed to do that. That is my challenge for having not been able to resolve this as quickly as I had hoped to do. I can say that I was under the impression and maybe the misapprehension that this matter was in the time prior to the July 21 hearing date rescheduled in front of Judge Crum. I'm not finding any corroboration to that effect in my docket sheet, but I thought at that point it would be probably preferable that we talk about it on the 21st before I would otherwise make a ruling. On the 21st, I think there were technical issues with at least one counsel's system, and the matter was continued by agreement of all the parties over to today's date. And with all of that said, I guess I would inquire first of you, Mr. Getz, is there any additional information or any new prayer that DCF has at this time?
No, Judge, that pretty much matches the notes that were left for me by Ms. Ridgway. Just to remind the court, though, there was a period of time where this child was placed with someone other than the biological parents, and DCF is asking for a judgment for those 4 months owed to the agency. Whatever the worksheet shakes out as, if we just multiply that number by 4, then that'll satisfy the agency. And as far as the issue or the case being before a different judge, I think these parties have a separate action, which is governing the custody, residency, and parenting time. And that may be why you're not seeing it on anyone's calendar, but it's Butler County Case 22 DM 88.
All right. With all of that in mind, Ms. Gilmore, is there any additional information or anything more that you would want the court to consider at this time?
There is, Judge, and I think some of this is complicated by the fact that there are a couple of different cases. That 22 DM 88 case does have some ongoing hearings with Judge Crum, but they don't really relate to child support. They are custody parenting time. Initially, I did ask counsel about the possibility of consolidating them, but because when I asked that initially, there was no pending motion, he was not in agreement. I don't know what his position is now. I'm fine consolidating this with that and moving it over. I think the issue today is how do we calculate this child support? What figures do we use? And I think back in June, I submitted a couple of different exhibits to the court about how to possibly calculate the income. One of the issues that we have is the DRA that was filed by Dad in November in this case lists his income. It's a short form DRA, and it lists his income as $2,800. It also lists an additional child support payment for a child who at that time was 17. I believe that payment no longer exists, and the court should be aware of that. In addition, I don't think his income is $2,800. If it means my client pays less, I suppose we could use that figure, but in reality, he makes somewhere much closer to around $65,000. We submitted to the court in one of our exhibits previously, well, actually counsel submitted in his exhibits previously sort of a printout of, I guess you maybe could call it a payroll register that had all of his clients' payments that he had received to date. We did submit that to the court, and that is what you should have received in our exhibit E as an elephant. Additionally, we looked at a couple of different other ways in which you could calculate his income, and I think I submitted that again as exhibit J today, but it was already submitted previously to the court, and it's about 4 pages or so, and it lists out it tells the court his 2017 W-2 had him making $58,000 as gross wages. We submitted a pay stub from August 31st of 2019 that had him making $45,000 and there were still 4 months remaining in the year. And then in 2020, he made $63,000, actually $67,000 in total. So I don't know why all of a sudden his income dropped down to $2,800. I think it's much closer to something higher than that. And I think the figure that we used in our worksheets, because there were a couple different ways you could do it. You could take his 9 pay periods and average per payroll. You could also average, the gross of the year, or look at the W-2s. And we actually pointed out to the court that in the guidelines, 2D has some language that talks about it may be necessary for the court to consider historical information and the seasonal nature of employment. For example, if overtime is regularly earned by one of the parties, then a historical average of 1 year should be considered. Additionally, it talks about in-kind payments, and that is 2F1D. When a parent receives significant in-kind payments or reimbursement that reduces personal living expenses as a result of employment, such as a company car, free housing, or reimbursed meals, the value of such in-kind payment or reimbursement should be added to gross income. In this situation, Mr. Fleury has a company vehicle, as I understand it, that he drives around in. It's a truck that's used because he has to travel around for part of his job. I believe in looking at that payroll register, there was sort of a drop off in March of 2023. So we've got, he's earning these checks that are $1,000, $1,100, and then all of a sudden in March we get one that's half of the amount. In August of 2019, if you take that amount that he was making and look at that paycheck stub, he was making $31.35 an hour. So we are now 3.5 years past that. I would think that it is higher than what he was making, specifically because he's been there for about 13 years at this point. He is an electrician, which is a highly trained profession. It's not something that just anybody could do. It was difficult for me, though, to be able to tell what his per diem is, what his company car is worth based on what I received from counsel, because it doesn't really tell us, how many hours. It says this is the week, this is the pay period, and this is what he was provided. So we don't know how many hours. We don't know if this is bonus. We don't really know from what was presented, but from historical data, we know roughly generally what he makes. Conversely, my client, she started working February 3rd of 2023. So in 2022, we did submit to the court for this hearing, it's Exhibit B, like boy, it's her IRS transcript showing what her income was in 2022. And she made less than minimum wage in that year. In the entirety of that year, she made, I believe it's $10,587 or somewhere thereabout. So she didn't really have any substantial income. A lot of that is because she was incarcerated for an arrest that happened when the parties were still together, right before the children were removed. And that, of course, got delayed until it was addressed. And then at that point, she had to serve some incarceration for that. She did find a job in February of 2023, and we did provide two pay stubs that we had at the time. And I think there may have been an additional 1 or 2 that came later, and that is in our Exhibit C for purposes of this hearing. And that has been provided previously. She had a gross income on March 3rd of around $1,500, March 17th around $1,500. So what we did is we looked at different ways that you could calculate her income. So the same 3 different ways apply. You can annualize it, you can take her year to date, or you could calculate her hourly times 40 hours a week. She is working for Dr. Varner, I believe it is, in El Dorado, and she works 40 hours a week. And what we did is we looked at those 3 different methods. And if you use basically, the long story short is there are 3 different figures that come out of those 3 different methods. And one is a high figure, one is a low figure, and one is sort of an in-between figure. So what we did in our proposed child support worksheets is we used that in the middle figure, so that 2728 for her, or 2738, sorry. We took the higher number, the lower number, averaged them out because we felt like that was the fairest way to know what her income is, just given the circumstances. The period of time that the children were in custody, I believe, was July to November of 2021. So there are roughly around 5 months there. And my client is not opposed to having to pay that. I think the proposed child support worksheet initially submitted by DCF had a figure of $184 that had both parents at a figure of minimum wage. And I think under the circumstances, when you look at a sync case, the focus is on the parents trying to get their lives together, use those financial resources elsewhere. I know in Sedgwick County, typically what judges do is they set it for each parent at $25 a month. Obviously, every county is different. If you use the 184 figure, that would give 5 months would be $920, but that should be divided by 2 because both parties should be equally responsible. So that would make each parent have a judgment of $460. I think that that's fair under the circumstances. My client's not opposed to that. She certainly wanted her children to be provided for. She makes $17 an hour right now. Obviously, she hopes that that will increase in the future. One thing that we submitted was a long form DRA. And we submitted the long form DRA because we are requesting consideration of the cost that she has in trying to be reestablished. She has right now 3 cases in Butler County District Court that she owes considerable fines on. She has 21 CR 364, where she owes $3,370, 21 TR 2797, where she owes $3,548, and 20 TR 2387, where she owes about $330. She's paying $650 in rent, $300 in food. Then she has a phone bill. She's got $150 or so for a gas bill, $200 for an electric bill on average, car insurance, prescriptions, gas and oil to get back and forth. So when we calculated that, she needed about just over $1,600, not including the payments that she has to make toward the court fines. And so she's trying to continue to be responsible and take care of those issues. But she's having a hard time doing that with this on top of it. The parties I think they are, for the most part, working together to some degree to try and work out something where there is an agreement. The last court hearing we had, there was an agreement between the two of them temporarily. So that at least is going well. I would think the dad would want her to be able to live and be comfortable. But then again, I guess you never know. We did submit several child supports, proposed child support worksheets, if you will. And what we did in ours and the ones that we submitted, there, of course, would be one child support worksheet for that period of time where the children were in DCF custody. But then after that, there would be a difference. And we calculated this, I don't know, probably 50 different ways. And I think the court could look at any of these and determine what you felt was the appropriate thing to do and what you felt the appropriate income to use was. We would ask the court to use the income figure for her $2,738 for her monthly income. And we are asking the court to take into consideration the history of this case, the history of the parties, everything that's been filed up to this point, the fact that my client does not have a degree of sorts. She does not have a specialized technical training like dad does. Dad has an electrician's license. My client doesn't have that. Historically, during their marriage or during their cohabitation, I guess, whatever you want to call it, she was a stay-at-home mom. So her job was really just to take care of the kids. That's what she did. So when their relationship was no longer a viable option, she had to start literally from ground zero. She had to find housing. She had to find a job. She had to take care of her court things, still try to comply with all of the things that are, required by DCF for the child in need of care case. So all things considered, Judge, my concern for her is if you saddle her with a high amount of arrearage starting out, that's not going to benefit these children. They are trying to put the pieces back together from being gone. My client is trying to be responsible and keep a roof over her head for these children and for herself. And we believe it would be appropriate for the court to give her an overall financial consideration adjustment. And certainly she knows that that's discretionary with the court. It's not required. It's not anything that has to be given. At the same time, it was her own actions that led to that incarceration. That's certainly true. But those actions were brought on in part by actions of both the parties. Their relationship had a certain dynamic to it. There were a lot of things that were going on behind the scenes. And I think it just kind of created a perfect storm where these things came about. So I think it's appropriate for her to support her children. She absolutely understands that, but she's asking the court to take those things into consideration and setting the appropriate amount. I have provided a number of exhibits to the court, and I would not be opposed to the court taking those under advisement and issuing the ruling that the court deems as appropriate. It will have in there the different manners in which I calculated those income figures. So with that, Judge, we would ask the court to issue a ruling that's consistent with the best interest of these children and in statutes and case law.
All right. Thank you, counsel. Mr. Andrews?
Thank you, Your Honor. Your Honor, based on the income information provided, Mr. Fleury's average gross income is $5,144.44 per month. Based on the pay stubs provided by Ms. Gilmore, Ms. Ross's average income is $3,227.07 per month. We agree that there is not another child support obligation that would be included in the child support worksheet or any other credits other than an income tax consideration to reflect the fact that Mr. Fleury is claiming the child tax credit every year for both children. We calculate that as being $167 per month in favor of Ms. Ross. Based on the child support guidelines, the child support amount should be $511 per month, and that's what we're asking the court to order. Mr. Fleury had nothing to do with Ms. Ross's alcohol addiction, nor her numerous prior convictions for driving under the influence. Her fines are a result of her own poor choices, and the children should not be deprived of financial support from their mother because of the poor choices that she made. So we are objecting to the inclusion of a overall financial condition adjustment.
All right. Thank you, counsel. Mr. Getz, anything more from DCF?
Well, I just want to, the only issue I really have before the court is the one of the judgment of what's owed to DCF, and to take $184 and multiply it by 4 and then have it and say that each parent is responsible for half of that number doesn't take into account the fact that there may have been a second case filed against father or that his number comes down on a different side of the worksheet. So it's 184 for mother, and if the agency wants a judgment against father, our worksheet would show his monthly number is $423, and that would be the $4 or the 4-month figure. So that 184 times 4 and then having it, that's just wholly inaccurate.
All right. I do want to review this, and I'm sorry I had failed in getting you an answer earlier on that has created more work for each of you. I believe that knowing a little bit more and understanding the dynamic concerning the companion case in front of Judge Crum, I am prepared to move forward, but I would like to review the documents a little bit before I make my final decision. Mr. Getz, I might be asking this unfairly of you, but if I'm able to ascertain what I believe is the appropriate support figure and rule on the other issues that counsel have raised, may I simply send those to counsel in the form of a letter opinion and with the expectation that perhaps your office could prepare a journal entry therefrom?
We would be happy to journalize whatever however you issue your ruling. We'll take care of that.
Okay. All right. Thank you. And I think just to have a kind of backstop to work against, if I were to set this on October 6th at 3 o'clock, would that work on everyone's docket?
October 6th works for me, Your Honor.
Ms. Gilmore?
You're muted, Lacey.
Sorry, Judge, that will work for me.
Okay. And I hope to have the ruling long before that and obviate the need for a hearing, but I just want to have that as a backstop in case I'm slow on the trigger. We could reconvene and I could just give you the ruling verbally at that time. So, all right.
Was that at 2:30, Your Honor?
I had it at 3 o'clock. Does that work for you?
No, that does work for me, Your Honor.
Okay. All right. Good enough. Well, I appreciate each and all and all of your contributions, and I will do my best to get by and through Mr. Getz. Mr. Smith appears in person and pro se. Mr. Carter appears in person and pro se. Shaylin Smith also appears in person and pro se. This case was begun back in June of this year with the filing of a petition to determine parentage. There were child support worksheets calculated contemplating potential proposed numbers should either Jay or Michael be determined to be the father. A service of process was had on each, and most recently, in July of 2023, there was a motion filed by counsel for DCF seeking that the court appoint a guardian ad litem. Counsel, do you have anything further you'd like to say about your proposed appointment of a guardian ad litem in the case?
Judge, the issue that we have before us is that Mr. Smith is the presumed parent by marriage at the time of either conception or birth. Mr. Carter is the alleged father. So the appointment of the guardian ad litem is simply to conduct a best interest investigation and provide a report to the court so that we can go through a Ross hearing and determine whether or not it's in the child's best interest to do genetic testing.
All right. Mr. Smith, do you have anything you'd like to say about the proposal that a guardian ad litem be appointed to talk with the parties and make recommendations to the court about what is in the child's best interest?
Best interest is I'm not the father, and if we have to go through with a DNA test, I will be willing to comply with that.
Okay. Mr. Carter, do you have any opinion about the proposal to appoint a guardian ad litem in the case?
No, Your Honor.
All right. And Ms. Smith, do you have anything you'd like to say on that question, ma'am?
No, I don't have any concerns. If we need to do a paternity test, that's fine, but I know who the dad is.
Well, and I appreciate where each of you are coming from. I do think that given all of the particulars, it does make sense to appoint a guardian ad litem in the case, and I will appoint counsel to do that. Let's see. I believe Stephanie Hughes would still be potentially able to do that. And if she is, I would like to appoint her to that position. Counsel, what sort of time frame would you like to consider for resetting of this case?
Judge, I think October 6th, that afternoon would be an appropriate time. That would give her about a month and a half.
Okay.
Talk to the parties, complete a report, make her recommendation.
All right. Mr. Smith, does October 6th at 3 o'clock work on your calendar, sir?
Give me a second. Let me look to what day that is. I can make it work. I just need to know in advance if it's going to be Zoom or not, since I do work out of town.
Yeah, and you'll be able to actually use the same meeting ID and passcode that you used today.
Okay. And can we also make sure we get the right address for mail being sent to? Because I did not receive for this court hearing. Shaylin had to actually send me a picture of it. 060.
Okay. All right. And Mr. Carter, does that October 6th at 3 work on your calendar, sir?
It does, Your Honor.
All right. And Ms. Smith, does October 6th at 3 also work for you?
Yes, it works fine.
All right. Well, we'll reconvene then October 6th at 3. You will be able to use the same meeting ID and password that you used today. And you can expect in the interim that Ms. Hughes or one of her colleagues will be reaching out to you. And I look forward to seeing each and all back here on October 6th. And we can take further action. Mr. Dodson appears in person and pro se. Also appearing in person and pro se is Ms. Miller. This matter was recently before the court in mid-July of this year, July 14th. On the docket. It was indicated at that time that Mr. Dodson wished to apply for court-appointed counsel. It's his indication to the court that he had indeed done so, and frankly, in line with what the court, I believe, had directed him to do, that is to apply here in Butler County. There was an issue in as much as it's a Greenwood County case, and it was thought better for him to apply in Greenwood County. I have no reason to doubt that Mr. Dodson had, in fact, filed his request for court-appointed counsel here in Butler County, but it was not a document that was available for us to find. There was some opinion or belief that it may have been sent to Greenwood County, but it wasn't showing up there either. So Mr. Dodson was directed a week ago today on August 11th to file that with Greenwood County. Mr. Dodson, did you indeed file the request for counsel in Greenwood County?
Yes, sir.
Okay. And we have not been given access to that at this point. We had sought to confirm whether it had been filed. It's not showing up electronically. However, it is our understanding that the person who would be in charge of that in Greenwood County is unavailable today. So it's possible that it just hasn't reached the court file yet. It was noted when we were last here that there is an arrearage balance, at least at that time, of $37,549. It was noted that there had been a $200 payment that had posted on July 17th. And I think at this point, the most critical piece is still to give Mr. Dodson the benefit of the consideration of the court as to whether he would qualify for court-appointed counsel before we go forward. I had put the case on today's docket in hopes of being able to more quickly move this along. That intention or that hope has been a little bit forlorn. But I think that the perhaps clearer way forward from the vantage point of today, and especially considering the court's immediately upcoming calendar, would be just to set this over a month or so, and with the expectation that when the person in Greenwood County is back at work on Monday, we ought to be able to get the copy of Mr. Dodson's submission. I can make a decision on that. And if counsel is appointed, they can be appearing with him. If counsel is denied, we will let you know that, Mr. Dodson, as quickly as we are able, and you can make decisions from that point about representing yourself or having hired counsel to assist you. But I think that it would be nice to move this forward. And with all of that in mind, I was looking at October 6th at 2 o'clock. Does that date and time work with you, Mr. Getz?
October 6th?
Sorry.
Is there a reason we're jumping over the September 8th?
No, you're right. I was completely on the wrong column there. Yeah, September 8th at 2 o'clock. Does that date work for you, Mr. Getz?
Yes, Judge.
All right. Does that date work for you, Mr. Dodson?
Yes, sir.
All right. And you, Miss Miller?
Yes.
All right. It will be continued to that date, and in hopes that either through retained, appointed, or representing himself, Mr. Dodson will be prepared to go forward, and we will go from there. Look forward to seeing each and all of you back here at that time, and see you on September 8th at 2 o'clock.
Who are you, sir? You are still muted. We cannot hear you. You need to push the microphone and unmute. We can see you, but we can't hear you.
Can you hear me now?
Okay, I can hear you now. Who are you?
Manfred Fleury.
Oh, well, we've been trying to get you for an hour or so. Okay.
Yeah, I've been sitting here waiting to get admitted into it.
We tried to admit you, but you never did answer and never would connect. Sorry. Okay, go ahead, Judge. Sorry.
Mr. Fleury, your counsel and counsel for Ms. Ross had come into the meeting and have made various requests from different perspectives, of course, and the court is considering which way forward makes the most sense. The case has been put into a posture where I may simply be delivering a letter memo to counsel, and it would be journalized. But there is a date that we did set on the calendar kind of as a backstop, October 6th, 2023 at 3 o'clock. So if you would please put that on your calendar, and certainly if you'd like to reach out to Mr. Andrews, he could give you greater detail.
Okay.
Thank you, sir.